Hello, my name is Chris Weisdorf. I'm a layman, a regular person, and I'm in finance. I've assisted people in the law as a non-legal professional, as someone who's not a licensee, not a lawyer, not a paralegal, without any formal legal training. I would like to talk today briefly about the law and the state of law in Canada. Unfortunately, the state of law in Canada over the past 4.5 years has been in shambles. It's been in a place I never thought it would get to in our lifetimes. It's in a period right now of disrepair, but it is not irreparable. If you read the release, you'll see that I have three points I'd like to discuss. The first one is the erosion of the separation of powers and division of powers, two different concepts, which directly threatens our democracy, specifically checks and balances on the government. The separation of powers is something I think we've all heard about it at some point. We've all learned about it in school. It is the powers that are distributed between the legislative, executive, and judicial branches of government. This separation of powers was determined by various legal philosophers over the centuries. It was incorporated in the United States Constitution. And before they actually incorporated it, there was the Constitutional Convention. So back in 1788, quite some time ago, there was a discussion on this, a substantial one. And it's called the Federalist Number 47. It's the Federalist Papers that gave rise to the Constitution and its first 10 amendments. And in there, they described the separation of powers as I just did. And they said that the concentration of power in any one branch of government is not only indistinguishable from tyranny, but is the very definition of tyranny. And I would submit today that that is exactly what we've had over the past 4.5 years. Governments at all branches, municipal, with respect to Councillor Robinson, has experienced that where executive power has run amok. They are allowed to subvert rights in terms of charter rights, as well as rights under the Human Rights Code, and have abused their powers in doing so. Unfortunately, no court has yet sided with that viewpoint that I just submitted. Executive power has outranked the legislative power and judicial power. If you recall back in 2020, 2021, 2022, the premiers of various provinces, as well as the courts, deferred, that is the proper term, deferred to the executive authority, the experts. They did so repeatedly, and that unfortunately has concentrated all power into the executive branch with respect to public health, but certainly with other matters as well, especially freedom of opinion, thought, belief, and expression, which is guaranteed under our Charter of Rights and Freedoms, as well as the Canadian Bill of Rights federally. There's also the division of powers, which is the division between federal and provincial powers. So in the Constitution, certain things are under federal, other things are under provincial, a lot is under provincial. What they've done is municipal and provincial governments have turned municipal bylaw and or provincial offenses, regulatory offenses, they actually turned them into hardcore criminal offenses. This occurred with Adamson Barbecue, that is Adam Skelly and his defiance and not shutting his restaurant down in November of 2020, defiance of the lockdowns, defiance of the public health orders, as well as we would see later, more than a year later, with the convoy escalating parking infractions and noise infractions, which would ordinarily be punishable under municipal bylaw, into criminal charges. And this continues to happen with respect to public nuisance or common nuisance. It would be with respect to public health, but common nuisance is the criminal charge, as well as obstruction pursuant to, as I said, municipal or provincial law, which the Supreme Court outlawed back in 1993 in a case called Sharma. This, as I said, threatens directly our democratic institutions and their checks and balances, and especially confidence therein. The second point is regarding systemic abuse of judicial notice, which undermines natural and fundamental justice and the integrity of our legal system. There's a specific definition of judicial notice. There's a Supreme Court case called Find in 2001 at paragraph 48. It is as such. It says a court may properly take judicial notice of facts that are either 1, so notorious or generally accepted as to not be the subject of debate among reasonable persons, or 2, capable of immediate and accurate demonstration by resort to readily accessible sources of indisputable accuracy. Unfortunately, this is being used to an extent that I never would have thought. Previous to the COVID era, judicial notice was generally taken of social science facts, of certain things that originated from government, but things that were, by definition, not scientific or medical. So these, because the government has been wrong so many times over the decades and even centuries with respect to science and medicine. Science and medicine does tend to change quite a bit. So judicial notice was taken of many different things regarding COVID with no ability to challenge the judicial notice other than to bring several experts in a broad capacity, as in the Adam Skelly challenge, which will be heard in October. So this is a substantial problem in that one is not permitted to challenge judicial notice. This is evidence that is brought into the court by the judges themselves, and it is something that has undermined confidence in our courts because evidence that was duly brought into the courts is not being actually properly assessed or decided upon. The final point is regarding the government's blatant disregard for the law, using what I would say are flagrantly illegal means to enforce legislation and bypassing parliamentary oversight. This is something that is, I've mentioned it quite a few times. It seems to have been adopted in some respects, but people don't understand the plethora of rights that we have in this country, especially in Ontario. There are so many different rights, so many different laws, like the Healthcare Consent Act and laws with respect to the Health Protection and Promotion Act rights in there, as well as many other statutory rights that we have in addition to the Charter of Rights and the Canadian Bill of Rights at a federal level. These various mechanisms have been hijacked or outright disregarded, as I said, blatantly and flagrantly disregarded by the government. The most flagrant abuses I've seen are under the Quarantine Act, Federal Quarantine Act, with respect to testing, simple testing under the Quarantine Act in Section 14. Testing may not enter into the traveler's body. That's Section 14, subsection 1 of the Quarantine Act. Subsection 2 allows one the right of refusal of the testing, of the screening. So many people were convicted as a result of asserting that right, even though it is right there in the Quarantine Act. Various courts, again, this is provincial court, but various justices of the peace have held, and unfortunately were not appealed until I assisted someone in their appeal, Milani Fernando, that anything actually occurred. People were either convicted or they entered into plea bargains where they agreed to be convicted for a lesser fine. On June 26th, the R.V. Fernando appeal was decided by provincial court justice Monahan, and Section 14 was upheld, and the conviction was struck as being unsustainable, and Section 14 was held to be, paramount to the order, which said that one must test no matter what. So testing was decided as to be illegal in terms of sustaining a conviction in provincial court. So this is something where the government has really run afoul of the law. It is right there in plain English, Section 14. In addition to the requirements to produce certificates of designation, that's under the Quarantine Act, under the Provincial Offences Act in Ontario, as well as under the Contraventions Act. They continue to abuse their powers. This conduct is plainly wrong, in bad faith, and abuse of power. And as I said, it continues to go on, and I simply demand accountability, transparency, and adherence to the rule of law, as is written by the legislatures and the Parliament of Canada. I invite everyone to simply join me in defending our Constitution and democratic institutions. And most people are not lawyers. One should still make an attempt to know their rights in the law and to exercise them. I would certainly ask that anyone who's had experiences, positive or negative, regarding the Quarantine Act or the Emergency Management and Civil Protection Act or the Reopening Ontario Act or anything else, to contact me. My availability is in the press release. I would also say, because these have far-reaching implications for Canada's future, to, in general, promote, exercise, and absolutely not stand for any type of abuse of power. I will end with a quote from 1858 from the great Frederick Douglass, who was a slave and became a free man. He said this: "Power concedes nothing without a demand. It never did, and it never will. Find out just what any people will quietly submit to, and you have found out the exact measure of injustice and wrong which will be imposed upon them, and these will continue till they are resisted with either words or blows, or with both. The limits of tyrants are prescribed by the endurance of those whom they oppress." Thank you very much.